The topic of today's discussion is going to be H1B visas and what should H1B visa holders know about the EB-5 program. So those of you who are here in the US on H1B visas and either have an employer who is not interested in filing a perm for you, or maybe that path is not available for many years, or if you already had a perm filed, but your backlog is long and you're not sure when or if you'll ever be eligible to get a green card. So specifically for Indian nationals and Chinese nationals stuck in long perm backlogs, this live session is for you. If you guys have questions, please post them. If there's going to be part of the topic that I didn't cover today and you may have a question about that, please reach out either in the comments or send us an email and I'll be happy to follow up with you. So, what does H1B and EB-5 have anything to do with each other? Well, in the last few years, the EB-5 Investor Visa Program has become an amazing solution for many individuals who are here in the United States in an H1B visa and are seeking to obtain their own permanent status, their own green card. Why the EB-5 Investor Visa does not require employer sponsorship, but most importantly, right now, the visa bulletin is current. So there are visa set-asides that are available to everybody, including Indian nationals and Chinese nationals. So if you are thinking about applying and adjusting status here in the United States, the visa bulletin as of March and actually April of 2026 is current. It is kind of anticipated to stay current for possibly a few more months, but we are getting up to the point where eventually we're going to see final action dates implemented on the calendars, meaning there's going to be additional wait time between when you can file for EB-5 and adjust your status. As of right now, March, April of 26, all the calendars for EB-5 visa set-asides are current. So it is possible to file your I-526E EB-5 petition and a concurrent adjustment. So what should H-1B visa holders know? So of course, I'll go quickly through the basics of the program. If you're considering this program, the program has been around for nearly 30 years. It has been changed, and some of the most substantial changes happened in 2008. And then it really became popular. So after 2008, we started to see thousands of applicants utilize the EB-5 Regional Center Program. Currently, the minimum investment amount is $800,000. You have to invest into projects that create at least 10 jobs. You have to show that you have earned your funds lawfully. But, and here's the good news for H-1B visa holders, you don't have to use funds from outside of the US. So if you have lived and lawfully worked in the United States and you want to utilize your savings to now file a petition for EB-5, you can use your US-based income. So in addition to showing the lawful earnings of your income, you also have to show path so that all the funds were accumulated lawfully. And of course, the important part is you have to invest in a project that will generate at least 10 jobs. You also have to maintain your investment in the project for a minimum sustainment amount. Today, the interpretation of the law is the minimum sustainment amount is around 2 years from when the money is available to the project. In the past, your money had to be in the project for 2 years after you obtained your conditional green card. That is no longer the case. So today's interpretation of the law is 2 years after the money was made available to the developer. Again, that may change in the future. So 2026 is a super important year. If you are considering the EB-5 program, I would really research it now. Meet with qualifying EB-5 immigration attorneys and see if it's the right move for you, especially by September 30th of this year, because a few important things will change. Number one, September 30th, the grandfathering protection expires. Those investors who filed before September 30th of 2026 are protected by what's called the grandfathering protection, meaning even if the program expires in the future and Congress chooses not to renew it, these applicants are able to finish their process. The program does actually expire in September of 27, after which we're hoping for congressional renewal, and we're very optimistic about it. But obviously, there's never a guarantee that Congress will renew the program. So that's why September 30th of 26 is so important, because it does create that protection. And of course, the visa bulletin may change and shift in the near future, meaning the allocation of visas, the wait times, everything may change, and concurrent adjustment might no longer be available in the near future. So also something to keep in mind. So what is so special, again, that H1B visa holders should know that pertains to them? So number one, H1B is a dual intent visa. So you can file for an EB-5 petition and file for a concurrent adjustment of status while you are in the United States. Some people choose to maintain their H1B visa while their petition is ongoing, which I think is always a good idea, but I'll defer to your immigration attorneys to advise you on that. Just full disclaimer, I am an attorney. I'm also a FINRA licensed and regulated investment broker, but these are informative sessions. This is not legal advice. This is not investment advice. Everyone's situation is different. So after learning what you learned today, if you're considering investing, you should speak to a qualifying immigration attorney about your specific abilities, and you should seek advice of a FINRA registered broker to understand what different risk profiles different projects carry, depending on which one you choose when you go to invest, to make sure you understand. And if you make a decision to invest, that you understand, all that's involved, right? So there's never a black and white answer that everybody is good for everybody. That's not true. For some people it's suitable, for others it's not. It's been a phenomenal solution for many, many people. I have been working with this program for 14 years, hundreds and hundreds of investors now, probably approaching around 1,000 that I've represented as an attorney and now represent as a broker. And great success stories, and so it has served a lot of clients well, but just like everything else, it's not for everyone. So do your research, and after watching these informational sessions, if you're interested, you should be working with an appropriate attorney and a broker to determine if it's right for you. Okay, so with H1B visa holders specifically, you can do a concurrent adjustment. You can continue to maintain your H1B visa. There is no backlog right now, even for Chinese and Indian nationals, if you're applying in one of the set-aside visa categories. I also want to be specific. There is no final action date on the visa bulletin, meaning you're eligible for concurrent adjustment. That does not mean that if you apply today, there may not be an additional wait time. So if you apply today, the backlog could form in the next few months, and you may, by the time your petition is approved, there may already be a final action date, meaning your green card is not going to be issued right away and there's going to be an additional wait time. However, as of right now, the visa bulletin is current. I recommend looking at the visa bulletin and also number of pending petitions in different set-aside visa backlogs, just to give you an idea of how long that additional wait time may or may not be. Another thing, you can use your US-based income. And generally speaking, that is super helpful for USCIS, because those are documents that can typically easily be verified. So let's dive in all the different tools that are available to H1B visa holders that are utilized often. Number one, you can use your salaried income and your life savings. Number two, if you purchased a house here and now you've built some equity in your house, you don't have to sell your house to make an EB-5 investment. You can use a home equity line of credit, and that's very often utilized by EB-5 investors who are here in the United States. You will need to provide documents to show how you originally purchased the home, that it was purchased with lawful funds, obviously that the home equity line of credit is from an appropriate banking institution, but that is something, a line of credit and proceeds from a loan is something you can use for EB-5. Furthermore, you can take a loan against your stock portfolio or against your retirement accounts. So all of those are appropriate source of funds, kind of sources and paths. But just keep in mind that if you're taking out loans and you're bearing interest, most EB-5 projects pay pretty much nominal return to investors, so less than 1%. So you want to be able to make sure that you can bear the cost of taking out this loan, because it's not going to be a situation where you take out a home equity line of credit paying 7%, and you're getting quarterly payments from the project that are 7%. Most EB-5 projects today pay less than 1% return a year, and they often don't even pay it annually. Sometimes it's paid as a balloon payment at the exit, right? And also, each project is a private project. There's no guarantee of return of the funds, no absolute guarantee, I would say. And so you want to make sure you're taking and investing the money you can afford to invest. So, home equity line of credit, income. You can take a loan against your stock portfolio. You can take a loan against your retirement funds. Some individuals have self-directed RIAs, so self-directed retirement funds. You can, in some instances, utilize self-directed RIA without taking money out of the retirement account. So you're not taking it out of the retirement account and you're not subject to the taxes and penalties. You keep it still in that retirement account legal kind of process, but now you're directing your funds, maybe from a stock portfolio to an investment in an EB-5 project. The projects in turn have to have a specific structure in order to be able to take in self-directed RIAs, but many of the larger projects qualify and they've registered for that structure. So you want to check as you're doing due diligence on your project if they're able to accept self-directed RIA funds. So as an example, if I have 300,000 in self-directed RIA, I don't have to pull it out of my retirement. I can move it now into the project and it's still in that retirement benefit saving legal structure. But for example, if I also have a spouse and they have a self-directed RIA and we want to use those funds, unfortunately, there's only one primary petitioner per family. So if I'm the primary petitioner and my spouse has a self-directed RIA, the only way we can use those funds is by taking them out of the retirement account, right? Because the ownership and the investment in an EB-5 project will only belong to one individual in one name. So self-directed RIAs can be used by just the primary applicant. All right, what else? If you have money coming in from foreign countries, I recommend to start working with your immigration attorneys in advance, especially with China. Fund transfers are slow because you have to be compliant with the local currency control restrictions. Same with India. We are about to pass a fiscal year mark on April 1st, and there are restrictions on transferring funds out of India, 250,000 per fiscal year per person. So this is actually an opportunity for a lot of investors who are receiving funds from India. They can transfer a little bit in March, so they can use up the 2020, 5 allocation in March, and then 2026 allocation after April 1st. So those and gifts and loans from your family members are acceptable. So gifts and loans don't have to be from family members. They just usually are, but if you have friends or family who are willing to gift you the funds or loan you the funds, you're welcome to use it. Also, if you are taking a loan from your friends or family to finance this, Keep in mind that any private lender who gives you any money has to fully source the income of that money. And you as an individual, you are allowed to take an unsecured loan. So if they can give you an unsecured loan, great. If they wish to secure their loan with one of your assets, then you will have to provide the source of funds documentation for those assets. So lots of different options of how people finance their EB-5 investment. Again, either their own accumulated salaries, or it's a combination of their own salary, home equity line of credit, a loan, or a gift from friends and family. All these different sources are available. Just keep in mind that they all have to be properly sourced and documented for your petition to be eligible. Another super common topic that comes up for a lot of local H1B visa holders when they're pursuing EB-5 are partial investments. So when we say partial investment, what that means is at the time of filing your petition, you've invested part of the funds, but not all of them. Now, being in the process of investing is something that the law allows. So you are allowed to invest part of the money and file your petition. However, normally it does create additional immigration risk. So please be very careful and work with an attorney who has a lot of experience in doing partial investments. And I'll explain why. Although the law says you're allowed to be in the process of investing, it's not very clear exactly at which point you need to send the rest of the funds. And lately, USCIS has been interpreting the law as that all the funds have to be in by the time they adjudicate your petition. So that's not a subjective standard. I also cannot confirm that it is based on the law. It's possible that that's going to change, but that is what we are seeing today in adjudication. So investors who made a partial investment and filed their petition and say they go into a project and their petition is reviewed in 4 months, if the remaining amount of the funds is not invested yet, USCIS may deny their petition. And sometimes they do so without issuing a request for evidence or notice of intent to deny. As a matter of fact, I'm aware of, now multiple instances where the second part of the investment was not in yet. The investor expected that USCIS, once they pick up their petition and start adjudicating, will send a client request for evidence saying, where's the rest of the money? And that would give the investor time to contribute the rest of the money and send proof of that to USCIS. But they were not given that choice. A denial was issued on the basis of the fact that not full investment is in. So that is the trend we're seeing in USCIS adjudication, and I would just want people to prepare for that. So partial investment, in theory, can be made, but you may want to make sure the rest of the funds are in before your petition is adjudicated. Unfortunately, there's no exact time to know if your petition is going to be adjudicated in 3 months or 12 months. Generally, we're seeing adjudication times between 3 and 9 months in rural projects. We're seeing those times between 1.5 years to 2 years in urban projects, but there's no clear promise. Another thing is if you are doing partial investment, you may not be contributing all the funds right away, but you must provide all the source of funds documentation in your original petition. Because the law also states that you have to be eligible at the time of filing. So if you contributed part of the investment, but you didn't explain where the rest of the money will come from, and you didn't fully document and source it, then USCIS can say you were not eligible at the time of filing. You didn't give them an opportunity to review those documents, so they cannot make an eligibility determination. So that's another thing that we're seeing USCIS get stricter on. They're a lot of times choosing not to send requests for evidence. If you did not submit full evidence of all your source of funds in the beginning, they can choose to issue a denial right away. Okay, let's see. What else do we see? Before we move on from partial investment, of course, have an agreement with the regional center if they're allowing you partial investment. Have a specific agreement until what date. and make sure you meet those dates. That could be another reason for denial. If they give you 60 days to invest the rest and you didn't invest that money timely, that could lead to a denial. And very importantly, when you do send in your final partial investment and you make that last payment, you want to make sure your immigration attorney immediately uploads these documents to your petition. There's now an online portal that allows you to submit additional documentation. We used to do it via interfiling, which was like a paper filing that could get lost. Now, when your petition is received by USCIS, they give you an online portal where you can go and submit additional documentation through this portal. So that being said, make sure it's documented right away, because if you paid the money but you didn't update your documents in your petition, USCIS can choose to deny the case. So that's on partial investments, and I would just encourage to be a little bit careful with that. If you can avoid it, I would. If you can have all the funds ready before the filing and just make a full investment and file, that eliminates all these additional things that you and your attorney have to account for, and eliminates potential additional reasons for a possible denial, right? But if you need to preserve a date for child status protection reasons, or you're unable to, you're trying to meet the September 30th deadline and you need to make a partial investment, just make sure you have identified where the future funds are coming from and properly documented it. Okay, so another thing is, if you're investing in September and you're saying the rest of the amount is going to come from a Christmas bonus of Christmas 26, that's, possibly legally not the qualifying source, because you cannot document it yet because you haven't received or even earned it. So USCIS can deny that case, saying you did not qualify at the time of September 30th. However, for example, if you do have the money, but it's sitting in a CD that expires in December, you can access the money earlier, but you would be subject to penalties and loss of interest. So you're choosing to wait until the CD term ends. Then you can properly and fully document those funds in the original petition that you're filing. So last but not least, also a lot of investors are asking about third-party lenders to regional centers. I'm going to give you my personal opinion, but then I'm going to tell you what's happening. I believe under the EB-5 law, you could take out a loan, an unsecured loan towards your EB-5 investment from different legal entities, right? Especially unrelated entities. However, there have been some lenders who structured to give EB-5 loans to EB-5 investors, and these entities were either somehow affiliated with regional centers or USCIS believed them to be affiliated. As such, USCIS denied a few cases, and part of their reasoning is that these investors did not meet the minimum investment amount. So if you go to a regional center and they say, hey, we're working with a lender, you only will need to invest 500, the lender will provide you a loan for 300, and you're responsible for this loan, and it's unsecured. In theory, that's doable and lawfully acceptable, and many of those cases have been approved, but it really depends on who the lender is and if they have any connection to the regional center or affiliation, because if USCIS deems that this regional center somehow is affiliated or related to the regional center, then USCIS may state, hey, a regional center cannot lend the money to EB-5 investors to then reinvest in their own project, right? That doesn't meet the minimum investment amount. At least that is their legal standing now. I'm actually very curious to see, because I believe some of these cases may end up in litigation, and maybe the federal judges will rule differently, because Maybe the federal judge will say, why not? If the regional center has additional funds, and now they're lending these funds to this investor, and the investor is paying interest, and they're choosing to reinvest this amount into the regional center, it may qualify, but I don't know that there is a high probability of that happening. And obviously, litigation on these types of issues usually takes a few years. And this is a novel issue. These multiple denials, specifically in cases where third-party lenders were used, started to come in at the end of the summer of 2025 and fall of 2025. So this is a pretty novel issue in EB-5. So as of right now, I'm not sure if there's still any lenders that are lending to EB-5 investors in an unsecured loan. I certainly know their number has diminished. And so that's another thing that I would be wary of. And last but not least, I mean, it is so important to use immigration attorneys that are experienced, that understand the EB-5 program. So if they haven't done a bunch of cases previously, that they have gone through extensive EB-5 training. But it's always very beneficial to have attorneys that have experience with this program, so they know exactly which documents to collect and how to manage your case and timing. And same goes for the regional centers that you choose. They're going to be the ones collecting all the documents and the reports for USCIS. It's a complex process. Just trust me on this. It's not easy. The compliance is a lot. And frankly, if you're not dedicated to this, a lot of newer players in this industry simply don't know what they don't know, right? If they haven't been doing this for years, they don't know which compliance procedures they need to be tracking and complying with, and it can cause mistakes. So my recommendation is also to look at the experience of the regional center, and then of course the experience of the developer and what the project is. And needless to say, I personally believe it's very prudent to use FINRA licensed and regulated investment brokers who specialize in EB-5, because I'm one of those brokers. And what we have to do as a broker is we have to perform our own independent FINRA compliant due diligence on each project before we present those options to investors. So when you're using professionals like this, you already basically are making sure that there was extensive due diligence done on the projects before you look at them. Does that mean it eliminates all the risk? No, it's still a real life business. It still needs to succeed, but it can certainly help to eliminate many unnecessary risks, like, going in fraudulent cases or projects that haven't begun when they said they started. And so it definitely improves your chances of making a better, more suitable decision for you and for your risk profile and needs. As we're approaching September 30th deadline, please keep in mind that everybody is going to be trying to funnel in last minute. That's kind of human nature, which means when it comes to priority date allocations and processing times of your cases, there may be a substantial difference between people who are investing in August and September of 2026 versus those who are investing in, say, May of 2026 and filing their petitions. Simply because towards the end of the deadline, there's always more cases going in, so more for adjudicators to review, right? So those are some of the things that H1B visa holders should know. And of course, if we have anybody who's an OPT who hasn't obtained their H1B visa yet, it pretty much applies to you as well. The one main difference is if you're here on an F1 visa or an OPT, you are still eligible to do a concurrent adjustment. You just have to make sure you're appropriately in the United States when you're choosing to do this, and speak to your immigration attorney. But that is also one of the paths that investors sometimes will take. International students or those who have recently graduated and are working here on an OPT can file for the EB-5 petition, file a concurrent adjustment, and obtain their green card here in the United States. So I hope this session was helpful. Again, if you have any comments, questions, send them over. But I do have one question that I'm happy to answer, and it's actually by a very dear and a very respected colleague. He's one of those great immigration attorneys that I mentioned if you're going to seek and look for an EB-5 experienced attorney. Michael Harris is one of them who asked the question. So the question is, who does the broker-dealer work for? The investor, the issuer, meaning the project, or both? I love that question. It's a great question because I get asked this a lot. The broker-dealer's duty is to the investor. So I, as a broker-dealer, represent the interest of the investor. My actions have to be in the best interest of the investor, not my own best interest, not any of the project's best interest. So when I present projects options, a project cannot hire me to do fundraising for them, meaning they cannot come to me and say, we need 20 investors, we're going to pay you this much to go out and bring us 20 investors. I, as a broker-dealer, would be violating my fiduciary duty if I committed to bringing all these investors to one project. Because when I speak to my investors, number one, I'm supposed to present them with choices. Number two, I'm only supposed to show them options that I truly believe are suitable for that investor. So if there is a project, it maybe even is a good project, but it's not suitable for a particular investor, I'm not supposed to be showing that project to that investor. So I, as a broker, will not take on any commitments, fundraising commitments to a broker, to an issuer or project because they want to hire us to get them a certain number of investors. What we will do is, if we like their deal, if we look at their deal, we like it legally, we like the structure, and we think it's a good deal, we will run our due diligence. If they pass our due diligence, we will add it as an option that we'll show to our investors, right? And related to this question, which wasn't asked, but it's an important part of it, broker-dealers, licensed broker-dealers, are entitled to be compensated by projects if we do bring them an investor. So if an investor uses my services, I show them 5 different projects, they decide that one of them is suitable and they will invest into it. I, as a broker-dealer, will be entitled to compensation from the project. So we are getting paid by the projects, but our fiduciary duty is not to the project. So that's a very important distinction. It's kind of like pretty much in any other investment advisor. If you're using an investment advisor, they will get paid a percentage of the transaction. They may get paid a percentage by the fund, but their duty is still to tell you what's good for you instead of trying to put you into products that are not suitable for you. Another thing that I like to mention to investors, there are a ton of EB-5 projects, and they are all competing with each other for attention from brokers and investors. So today, the compensation most of these projects offer is very, very similar. So sometimes investors get worried, like, is one project paying you triple commission versus another paying a third of that? And could that subconsciously sway your decision? Fortunately, we're not seeing such drastic differences. There's sometimes in the timing of compensation and so on, but it's very similar. I mean, I think also if you're a responsible, ethical adult, you're not going to put your clients into projects that are inferior, even if they try to incentivize you a little bit financially. So, important question, yeah. And I'm glad it answered that question. But I also just want to bring up one more thing then on that point, because I did compare the transactions to kind of investment brokers or real estate. Like in real estate too, if you're using a realtor, they will get paid by the seller, but their duty is to represent you. Super important distinction and what it even means to be a FINRA broker. Here in the United States, if you're representing EB-5 investors and getting compensated for it, you must be a FINRA licensed and regulated broker. What that means is we've taken a lot of financial tests and passed them. we have our license hung at the broker dealer and we're constantly doing all sorts of compliance things, but we are actually audited by FINRA every, I believe it's 3 to 5 years. FINRA comes and audits proactively brokerages. They will look at the internal files and actually check to see what recommendations we made to different investors, how we pre-qualify these investors, why we made these recommendations. And if they think that based on the documents, we are providing advice that is not in the best interest of investor, they can penalize us financially and fine us. They can revoke our licenses, they can suspend us. So there's a very stringent kind of review process. Like, we cannot just doopsie doodle and not do the work that we are obligated to do. By distinction, when I was a practicing attorney, I also had to get licensed by the Florida bar, but the bar never showed up to my office. They don't come and they proactively don't audit you. In order for me to get in trouble with the bar, I would have to do something wrong. Someone would need to file a complaint, and only then would the bar investigate. FINRA is much more proactive. They actually come to brokerages every few years to look at both our process of due diligence for different projects and what due diligence we've done, and also our client files to see how we presented the clients, what we suggested to them, how we kept our notes, and so on. So I think all of those things are great things because they help protect investors, and they also create accountability for people who don't do things the right way. And that's also answers sometimes the question about the difference of using a broker here in the United States, a licensed broker, or sometimes we see agents abroad. There could be some agents abroad that work with the EB-5 program and give recommendations to investors on which projects to invest in. Because they're abroad, and if their investors are abroad, they can legally get paid by the project. However, those agents are not subject to US regulation and control. Some of those individuals might be very, very competent and maybe very ethical. So they may be giving you actually really good advice. But some of those individuals have no background in finance. They don't do any project due diligence, and they be just giving you advice based on what looks good in marketing. So just keep that in mind when you're picking your professionals. Understand if this is a licensed, regulated professional or not, what their background is, how they do the review, and kind of where they do this lie. But thank you so much for being here, and thanks for the questions. Again, I hope this was super helpful. Give us topics on next live sessions, what you want me to answer. And if anything was not answered and is a little bit more urgent, feel free to reach out or comment, or go on eb5support.com and schedule a call. Thanks so much. Bye.